there's a few things that an employer can do, very simple things that they can do to help inoculate themselves from a charge of harassment. The courts have recognized what we call a safe harbor for an employer who acts reasonably to try and prevent sexual harassment from occurring in the workplace. And even if it occurs, they say, in most circumstances, if you've done these 3 simple things, you will escape liability. So what are those 3 very simple things? You touched upon one already. Having a written anti-harassment policy in place that contains a complaint procedure. Tells people what to do if they have a complaint. Who do they go to? Okay? And you distribute that to everybody. So check. Most employers have that one. They kind of fall short in the next 2. The second element that you need to have is that you need to have periodic training in your policy and generally in the law of sexual harassment. What do we mean by periodic? Don't know. I think that depends on your workplace. Every year is certainly fine. Every other year is probably fine as well. The EEOC says the training should be done live. And I think the reason why they say that is kind of obvious. Those of us who do online training, what are most people doing when they're doing their online training?
Checking their social media, answering emails.
You're multitasking. You're not paying attention. Live training, if it's done by somebody who's engaging, is very powerful. And people pay attention. So I think that's why the EEOC says the training should be live. But it's not a requirement at this point in time. It is a requirement in some states, but it's not a requirement here. So you have to have the policy, you have to have the training, and then if a complaint is brought to your attention, you conduct that prompt investigation. And if a violation is found, you take appropriate remedial action. If you do those 3 things, in most cases, not all, but in most, the employer can escape liability because the courts will say, you did all the right things. You did your best to make this not happen, and you took care of it when it did. We're not going to hold you liable. Now, let's say you have the policy, you have the training, but the employee doesn't invoke the complaint procedure. What happens then? Well, in that circumstance, the court's going to say, under this safe harbor, the courts should say, hey, employee, you didn't keep up your end of the bargain. This is a 2-way street. You were given a policy, it has a complaint procedure, and you were trained that you had to come forward and complain. And you sat silent. You didn't give your employer an opportunity to fix it and address it first. So don't come crying to us. And in theory, the court would dismiss the case in most instances.
So those 3 things. Again.
3 very simple things. Very simple things that every employer can do. And you know, there's sometimes some pushback because it costs money. But my gosh, it's pennies as compared to the cost and the time and effort that you're going to spend if you're having to defend a legal claim.
Right, not to mention the loss of productivity.
That's exactly right.
Your senior management is now devoted to meeting with lawyers as opposed to working on your strategic thinking.
Absolutely. And you'd be surprised how much better workplaces do become with some good training. You know, people come in, you know, when I give it, people come in, you know, they're kind of grumbling. Who likes to go to training?
Right.
And I will say by the time they leave, people come up and say, oh my gosh, I'm so glad you gave us that presentation. I learned a lot.
Right,
you know,
I didn't know this.
I didn't know this.
Yeah.
And maybe I better curb some of my behavior. It's a good thing. It's a good thing. And don't be penny wise, pound foolish. You know, you have to invest in your company, and this is one of the things you need to invest in.